Hi, everyone. I'm Elaine Quijano. Prosecutors with special counsel Robert Mueller say former Trump campaign chairman Paul Manafort violated his plea agreement by lying to investigators. In a statement released Monday, prosecutors said Manafort lied about, quote, a variety of subject matters which constitute breaches of the agreement. Manafort's lawyers deny the charges and say he was truthful when meeting with investigators from the special counsel's office. Manafort is likely to face up to 10 years in prison in connection to financial crimes charges if prosecutors don't ask for leniency. I discussed this earlier with Keir Dougall, a former assistant U.S. attorney in New York's Eastern District. So, Keir, what does this now mean in the case of Paul Manafort? How significant a development is this?
It's a very significant development. As you mentioned, the prospect of leniency will no longer be available to Mr. Manafort based upon the motion of the prosecutors. And being in breach, it means that he's facing a substantially higher term of incarceration. It also means that the prosecutors have made a decision that they don't intend to use his information or testimony going forward.
And how much of a setback is this for the Mueller team?
Well, it may be, it may or it may not be. It's hard for us to know right now. So certainly, based on prior reporting, they spent a great deal of time with Mr. Manafort. And to the extent that they obtained leads or other information which was partly truthful or somewhat truthful that Mr. Manafort supplied, they'll be able to follow out leads and develop that evidence. But what it means is that they won't be able to use him directly as a witness, and nor will they be using them for leads and other investigative means going forward.
When news initially broke that he was entering into a plea agreement, I think some folks were perhaps surprised by that. I'm wondering how unusual it is for a situation like this to develop, Keir, where you have someone that has entered into one of these plea agreements, then be charged or accused of violating it.
Well, it is somewhat unusual, and ordinarily the decision to plead guilty and to cooperate is usually done by defendants who have sort of come to terms with the fact that their situation has become overwhelming, that their sort of their route to redemption or to at least controlling the circumstances they find themselves in is to cooperate when there's an offer by the prosecutors that allows a defendant to cooperate. It doesn't happen in every case, but ordinarily a defendant who makes that decision sort of commits themselves to that course of action, and then frankly does everything possible to make sure that they're truthful and that they're discharging the agreement. This is unusual.
There's no detail. I was looking at the filing earlier on specifically what may have been the factual inaccuracy or whatever it was that specifically was in violation, other than that, what we outlined earlier, that in fact that he did not necessarily fulfill each and every one of the obligations under the agreement truthfully, completely, and forthrightly. But I wonder at this point, how quickly now does this process move forward? You have both Paul Manafort and you have the prosecutors saying that there's no reason to delay the sentencing.
Right. So the next steps will be, completing a pre-sentence report, and then there may be litigation over the breach, over what we don't know right now, and what you just mentioned, Elaine, which is what specific facts the prosecutors believe that Mr. Manafort was untruthful about. It could be anything from, an outright lie about some part of just some subject in their investigation to something where he's trying to protect an individual or where he's effectively trying to throw somebody under the bus in a way that is untruthful. It can sort of be a range of things. So there potentially will be litigation by Mr. Manafort's lawyers about whether or not he did or did not breach the agreement. He can, potentially make arguments to say that no, he didn't breach the agreement. Presumably, if the prosecutors have used the same level of care that resulted in his convictions in Virginia and his guilty plea in the District of Columbia, if they've used that same level of care, and we don't have any reason to think that they haven't, then they will prevail when they demonstrate in their papers what particular thing it was or things that Mr. Manafort lied about. The court will find that he breached the agreement, and then instead of looking at a reduced sentence, he will be looking at a effectively likely a sentence for the rest of his life. I mean, the guidelines range now is approximately 24 years, plus or minus. The plea agreement in the District of Columbia has some limitations based on the charges there, but don't forget that Mr. Manafort also was convicted of multiple counts in the Eastern District of Virginia. So those counts could be applied consecutively, should the judge choose to throw the book at him, or judges.
So I just want to make sure I'm clear. So, Keir, you're saying there is still the possibility that, in fact, Paul Manafort's lawyers might somehow challenge this notion that Paul Manafort violated the plea agreement? Because as I'm looking at this filing here that was submitted by Bob Mueller, it says at the end, the defendant reports that, I'll just skip to the end, given the conflict in the parties' positions, there is no reason to delay the sentencing herein. And he asks the court to set a sentencing date in this matter. And so, and that follows a sentence in which it reads, Manafort has provided information to the government in an effort to live up to his cooperation obligations. He believes he has provided truthful information and does not agree with the government's characterization or that he has breached the agreement. So it's possible, you're saying still, that in fact his lawyers might decide, even now, to challenge?
Right. So the hearing itself is a vehicle by which the court will resolve several different factors. Some of them ancillary, about his personal history, about there are lots of different factors that go into sentencing. But this dispute, apparent dispute that we're surmising from this filing, is one that could be the subject of a hearing, of a challenge, of effectively of litigation in connection with this with the guilty plea. So the government, it's now a contract. The guilty plea is a contract. And the government is saying that it's been breached, and Mr. Manafort is saying that it hasn't been. And so that's the type of dispute that courts settle every day, and it is likely that Mr. Manafort will challenge the government's claim of a breach at this sentencing hearing. So there potentially could be testimony or witnesses called on that specific point.
And we might learn, Keir, at that moment what exactly, perhaps more specifically, Special Counsel Mueller was referencing when he said that Paul Manafort was not truthful about something.
Correct. We'll likely learn in a court filing in advance of the actual hearing what the government contends the violations were. It's possible that the government could charge Mr. Manafort with further crimes. If he's lied in connection with his interviews to the government, those are crimes. They may choose not to do so and simply litigate it in the context of the sentencing of the convictions they've already obtained, both in Virginia after the trial and in the District of Columbia upon Mr. Manafort's guilty plea. But either at the sentencing or via separate charges, we will undoubtedly learn what it is that the government believes Mr. Manafort lied about.
All right. Keir Dougall. Keir, thanks so much for helping us better understand this. We really appreciate it.
Thank you, Elaine.